Good morning, everyone, and welcome to the October 1st, 2025 sitting of the Massachusetts Appeals Court. To my right is Judge Brennan, to my left is Judge Smyth, and I am Judge Grant. We are very fortunate today to have some interesting cases and some very experienced counsel, as well as some brand new counsel. And we are looking forward to hearing your arguments. For those of you who have been here before, you know that there are lights on the podium that when it's your time to speak, the light will be green. You have 15 minutes for your argument. When the light turns yellow, that means you have 2 minutes left. And when the light turns red and starts flashing, that means your time is up. And I may ask you to wrap up at that point, but when you see the yellow light, you may want to think about wrapping up the points of the main points of your argument. We have no rebuttal in the appeals court, and you should know that we have all read your briefs very thoroughly, and we may have questions for you. So my advice to you is that you get right to the heart of the issues rather than dwell too much on the facts that we're already aware of. So with that, I will call the first case. It is 2024 P820, Commonwealth versus Jared Gill. Good morning, Ms. Peterson.
Good morning, Your Honor. Good morning, Your Honors. My name is Attorney Kim Peterson. I represent the appellate, Mr. Gill, who is with us today in the gallery. May it please the court. Big question, why don't we just remand this case? And I understand where that's coming from. I applaud my brother's attempt. However, the convictions for A and B cannot stand where these complaints charged a facially unconstitutional charge. Well, it gets right to the heart of it, Your Honor. When this was charged under these, the Commonwealth did not show at the plea that he was a Massachusetts resident. The complaints they took out themselves state that he was a New Hampshire resident, as well as they indicated in the plea itself that his plates on the car were from New Hampshire. That was
actually on the plea.
Yes, Your Honor.
If you look at the green sheet, and they did a Rule 4 conference with the probation department here. It's at page, I think, 25 in the appendix. It says, lives in Mass. Because that's what they have, I think probably because he wanted to be supervised on probation. So
that's correct, Your Honor.
He told them he lived in Massachusetts. Now, granted, that was 5 years later.
That's correct, Your Honor. The date of the offense is April of 2018, yep. And everything at the plea hearing pointed to that. That is the only thing at the plea hearing that may have mentioned of Massachusetts, but as Your Honor pointed out, that's dated 2023, far before.
I'm just asking because you said everything at the plea hearing indicated he was a New Hampshire resident, except for apparently him telling probation he lives in Mass on
that date.
4/6/23, yeah.
23.
Sure.
That's the problem, Your Honor.
Okay.
Now, even if the court does not agree with that, then Crowder then applies, Your Honor. And it does so, and my brother does concede, that if at the time of the plea, Mr. Gill was a New Hampshire resident, a dismissal is granted. They concede that that is what it falls under 131F. The same holds true for Crowder. If they concede that he's a Massachusetts resident, then the Commonwealth had the burden at the plea to state such.
So does your argument rest on the fact that Donald found that the Massachusetts statute for pertaining to non-residents is unconstitutional on its face and cannot be severed in its entirety?
Yes, Your Honor, because that's what Donald says. It's non-severable. It says it cannot be severed, as well as on its face it is. It becomes the Commonwealth's burden not only to show that the person did not have an active license, but it was not a Massachusetts resident. And I think after Godotto 2, then it starts to say, well, you don't get a dismissal. You get a motion for new trial because the Commonwealth didn't really get that bite at the apple. They didn't know at the time that that's what they had to prove.
Attorney Peterson, let me ask you, and I'm going to throw it, because I will confess, I didn't read it fully. I read part of it today, and I only did so because another justice sent around a memo, but the SAC came out with a case yesterday that abrogated Donald, which is Rodriguez, on those issues. So what, did you have a chance to look at it? I don't expect you might have.
Just out of the grace of God, I actually did see Rodriguez.
Okay.
It does not apply to this case. That is a resident case. The facts were completely different. It does not apply. So I do implore you to read Rodriguez, but it does not apply to this case. This case definitely falls under Donnell and Crowder.
And then, go ahead, I'm sorry.
Yes, Your Honor.
What I think my brother Brennan was saying is that Rodriguez, the facts aren't square with our case here, but the holding, I think it's footnote 8, they abrogate O'Donnell, holding that it's facially invalid for out-of-state. It's a 131F.
131F, Your Honor.
So that is no longer the law, O'Donnell. I think that's the concern.
You know,
Or that's the question asked.
And that becomes a question. However, if Crowder still applies, then it would still fall under the dismiss. It would still fall under a motion for new trial, Your Honor.
So he may face the same, or it may be the same analysis whether he's a Mass resident or out-of-state resident.
That's correct, Your Honor. That would be our alternative argument.
Right.
Not that it's remanded for, again, new filings by the defendant to prove that he was a non-resident, but that the burden still stays upon the Commonwealth.
Well, let me ask you first about the remand. Is your position that Justice Gaffney decided not to decide where the defendant was a resident, or was unable and couldn't decide? And let me read what he wrote on Record Appendix 291. Based upon that hearing and the evidence presented, the court is unable to say what his state of residence was on that day of the arrest, April 28th.
To answer your question,
How do you interpret that?
This has been a long and winding road for this case. I believe the lower court judge felt he didn't have to make a decision. I feel like at the time that case law was enacted, it was Guardado 1 and Guardado 2. And he did not have the benefit of Donnell or Crowder. I believe he says in his opinion, it doesn't matter. I don't have to make a decision because nothing in Guardado has abrogated the holdings. It still applies to non-residents. And then in March of 2025, here comes O'Donnell, and later in March of 2025, here comes Crowder. So with that, it changes the lens that this court now has to look at the case. This is a de novo review because it is a constitutional standing. This court is more than able to look at the documentary evidence that was presented not only at the plea, but at the evidentiary hearing.
Well, there was also testimony.
There was, Your Honor, but
So
as
we
you know,
can't make credibility determinations, right?
you can on the documents, Your Honor. As you know, you can on the documents, not the evidentiary stuff is going to have deference to the trial judge unless it's clearly erroneous.
Which he didn't seem to do. Let me ask you, if I could
And he
just
gave
follow
us
up on
nothing.
Justice Smith's question.
Yes, Your Honor.
Just assume for the moment that Judge Gaffney says he was unable to make a decision based on the evidence at that hearing. Who had the burden of production on a motion for new trial?
Then, back then, at that...
The motion for production, when I say that, to demonstrate that there was something missing either at trial or at a plea, right?
Viewing it at that lens, Your Honor, at that snapshot of it, I would probably say the defendant.
Right.
However,
So to the
law
extent
has
that,
changed.
to the extent that residency was an issue, if neither is proven, isn't the default then that it's up to the defendant to prove it and he didn't do so at that stage of the proceeding?
At that stage, Your Honor.
Which is why you think a remand would be a better choice. Or, no, you think we should look at the documents?
Because I think the law has changed. The law has changed substantially, and I think, I have to revisit Donnell now, but Crowder has not been exemptified, and I think it still falls under that. And that at the time of the plea, the Commonwealth did not show.
So can I ask it on that?
Sure.
Because I'm doing the math. It looks to me like the plea was after Bruin and before Guardado 1 by a week.
1 week, Your Honor.
1 week. But so then, doesn't that mean that Guardado 2 applies and that the Commonwealth was not on notice? Because they hadn't gotten the benefit of Guardado 2 yet. So where the date of offense was April of 18, the plea was April 6th of 23.
That's correct.
And then April, I think 13th of 23 is when Guardado 2 came out.
That's correct, Your Honor.
So why aren't they in the zone where they were not required or not couldn't reasonably be expected to know that that was an element of the offense.
That's Gordado 2, though, Your Honor, and that states that a new trial would then be given at that point. That's
Right.
exactly what Gordado says. If you're in that little,
Right.
little sweet spot, you've got to give them a new trial. It's not a remand, it is a new trial.
Well, that's on the trial, but on a plea, right, a remand would be for, well, it would either be to determine whether in fact he was a resident or not a resident, right? And then best case scenario for your client, he gets a new trial.
Best case scenario is he gets a new trial, and our argument continues to be, he gets that new trial, because it was not shown. And we're not asking for anything more than that. And I think that's the third argument that I list.
Is his state of residency an element of the crime that the prosecutor was required to recite at the plea?
According to Gordado 1 and Gordado 2, and now Donald, which we have to revisit, and Crowder, yes, you have to show not only that they don't have an active license to carry or not permitted to carry a firearm.
But the prosecutor said the defendant did not have an active license to carry.
But didn't say Massachusetts. And the complaint by the Commonwealth, as well as the statement of facts, include New Hampshire residency. At no point in that plea was Massachusetts mentioned. And
So is it your position that in every plea, now the Commonwealth would have to say the defendant does not have a license to carry in Massachusetts?
I think that is too broad, and I would not ask that court to adopt that. But I would say in this instance, yes. In future ones where they blame when they say a New Hampshire or out-of-state or non-resident,
Based on what? Based on what information would are you saying there was a general understanding that he was not a Massachusetts resident at the time, or that there was even an issue or was raised in any way?
it was on the complaints. The Commonwealth never changed their complaint to a date of offense.
Right. But then the DA gets the green sheet where it says lives in Mass.
From 2020, in
No,
2023.
but right. I mean, geez, information on the complaint about residence it seems to me, a pretty high bar to expect that everybody, sometimes, as you say, pleas happen 5 years later, that people are going to look back at that.
But it's the Commonwealth's obligation, Your Honor, to set forth the facts in a plea hearing. And it's their burden to show that all the elements are met. And when they're not met, that becomes an injustice, because someone should not be convicted of something that is not a crime. And at the very least, they get a new trial.
I mean, in fairness, he did plead guilty to it.
That's correct, Your Honor. But in the past, many people have pled guilty to things that should have not been pled guilty to and that become unconstitutional. And there's no way for the defendant to have known that. In fact, the defendant first filed his motion for new trial, I think, barely a month after this. I mean, granted, he did allege Second Amendment violation in a very broad way, but it was until he found counsel to assist him that these things came to light.
As far as our ability to make factual findings based on the documentary evidence, I understand that the police found an unsigned resident Massachusetts tax return in the defendant's vehicle. The judge said the defendant filed a Massachusetts state tax return listing a Massachusetts address for the 2017 tax year. So when the judge made a finding that he filed that, can we make a finding that he didn't file it?
Yes, Your Honor, because it's documentary evidence, and under such, you can independently review such evidence. Under Tremblay, you are not bound by the federal law, Your Honor. You are bound by Massachusetts state law, which says you may independently review such. And as Your Honors have seen the record appendix, which is quite lengthy, not only was that not signed, the Commonwealth brought no one in to authenticate it. Nobody. Maybe it wasn't signed because it was wrong. Who knows? But again, that was not brought into the plea agreement, a plea hearing. But I will say, none of those tax forms were authenticated or showed anything to help the court make that decision. They were not filed, they were not certified by the DOR or the U.S. Treasury. They didn't even bring in Maria, who, supposedly signed it, to say, I prepared them and this is the information the defendant gave me. None of that was brought in. It is hearsay upon hearsay, and it's unsubstantiated. In fact, the defendant's mother, who testified at the hearing, said, yes, it says that, but that's not his signature. That's not where he lived. He lived in New Hampshire.
So once again, isn't that an issue of credibility?
That becomes an issue of credibility,
Yeah,
Ron.
yeah.
That does. However, the whole filing, it's clear that wasn't filed, and that's clearly
Well,
erroneous.
if we were to remand for an evidentiary hearing, wouldn't it be quite possible that the prosecutor would summons the state tax returns from the Department of Revenue and call the probation officer who wrote "lives in Mass"?
That's correct, Your Honor. But we're not asking for a remand. We're asking for a motion of trial because it's the Commonwealth's burden from the very beginning to have done this. And they get a new trial because they didn't know all this was coming down the pike for law.
But again, is their burden on the plea, you would agree, is different from their burden on a motion for new trial?
That's correct, Your Honor. But
Okay, so if
Crowder,
we're talking about who had the burden to produce evidence sufficient to vacate the plea at the motion for new trial, that's the defendant.
that's correct, Your Honor.
Okay. So if it's a tie, if you will, seems to me the tie in that situation goes to the party that doesn't have the burden.
So the problem becomes, Your Honor, that
Judge says,
Crowder-
"I can't
then-
do
then-
it."
Then Crowder makes no sense. Then
I'm
Crowder
saying if the
doesn't
judge
apply.
says, "I can't make a decision on this evidence," then isn't that another way of saying the defendant has not satisfied his burden of producing evidence at this hearing that he is not a Massachusetts resident, or wasn't at the time of the offense, and in fact was a New Hampshire resident? Isn't that?
Possibly, but the judge did not have the insight of Crowder at that point. And I think if he did, Judge Gaffney would have made a different decision because he was very in tune to what the law was going on. He was very aware of what was coming and what was not coming. Do you know what I mean?
Yeah.
He understood what could be happening. But his idea were to hold another hearing, should it allow, is not what Crowder says. Crowder supersedes the judge and now says, you know what, he gets a new trial, at the very least.
Thank you, counsel. Your time is up. Your argument was very
If I
helpful.
may, Your Honor, just one housekeeping measure. The Commonwealth stated that we had waived the 10H. I had not. In my post-evidentiary motion dated 6/2024, I reaffirmed all our arguments. So under our view, we did not waive those because we filed a notice of appeal that would have encompassed that, Your Honor, just as a housekeeping measure.
Thank you.
I appreciate the court's time.
Thank you. Mr. Padalano?
Good morning, Your Honors. 88 Matthew.
Wait a minute, you're
Oh.
getting a scary red light.
Gotcha. Good morning, Your Honors. 88 Matthew Padalano on behalf of the Commonwealth. Your Honors, the trial court has the sole ability to make credibility determinations and decide questions of fact. In this case, there is a central question of fact that remains unanswered, that is outcome dispositive. And I will point out that the defendant repeatedly made reference to documentary evidence. There's also Glenda Patton's testimony in which she says that the defendant spent every weekend at his girlfriend's residence and would go from Friday to Sunday. The defendant was arrested on a Saturday. So there is some testimony that needs to be determined to be credible or not credible. And for that reason, the Commonwealth believes that a remand is necessary. Now, in this case, the question is, of course, whether the defendant was subject to 131F at the time of his arrest, and accordingly, whether or not he was a non-resident. That non-resident definition is distinct from the types of casual ways that we use the term resident in other pleadings, such as on the forms. You could very well live in Massachusetts but not fall within the terminology of resident for the statutory purposes. And that's why I cite the Paul case that gives the definition of what a resident means for the statutory purpose.
So you suggest that we might want to clarify what a resident means in the context of this statutory scheme, is that right?
Yes, so
Walk me through that, because it seems to me that residency is a pretty well-established concept. You know, it's presence and intent. I mean, I'm mutilating the actual definition, but it's
sure, Your
the intent
Honor.
to stay in the place.
My goal is basically to prevent a revolving door of litigation between the trial court and the appeals court, and to give the trial court the clearest definition of what factual questions they are tasked with answering. I know that it seems very common sense as to what resident means, but in this case, I think it's important because this is right on the line of whether or not the defendant was a resident or not at the time of his arrest. So from our perspective, the term non-resident clearly just means someone who does not fall into the category of resident. The Paul case describes resident as someone who is in Massachusetts with an intent to remain for an indefinite period of time. So the inverse of that would be somebody who is either not in Massachusetts or is in Massachusetts without some intent to remain for an indefinite period of time.
So if the defendant was living in Lowell every week from Friday to Sunday, and with his mother in New Hampshire the other days of the week, and he had a intent to remain on that schedule for an indefinite period, where's he a resident?
So he's in New Hampshire with an intent to remain in New Hampshire? I'm sorry.
Well, he intends to remain in New Hampshire Monday through Thursday, but he intends to remain in Massachusetts Friday through Sunday.
So, Your Honors, I think that it would be a question of intent, but in that situation, I think he could be a resident of both states.
But we're talking like dual citizenship.
I think that's essentially what the statute imagines. I mean, you can imagine a situation in which it's the inverse, right? He lives in Massachusetts except for one day of the week, right? That person is clearly a resident, even though they intend every single week to leave Massachusetts.
I guess your point is well taken on that. So your point is, let's say someone splits time. They're in one state 3 days, or 3.5 days, in the other state 3.5 days a week. Would we want them to be licensed to carry in Massachusetts, even if they vote in New Hampshire and pay taxes in New Hampshire?
And I believe the statute imagined that they would want to be licensed in Massachusetts. I mean, in Massachusetts, we have many people who fly to Florida seasonally, right? And that person knows come December 1st, I'm leaving for Florida, right? Simply because they have some definite period in which they believe they're going to leave doesn't mean that they shouldn't have to get a license to carry in Massachusetts. And again, these confusing top questions, these confusing hypos, are why I believe an instruction is advisable in this
Why is that
situation.
not for the legislature to clarify?
So I believe they should clarify the term non-resident, but where they haven't, the courts are tasked with determining what is the plain definition. And I think the Paul case decides what the legislative intent is where it's not defined of resident. And I concede that non-resident is clearly a different word, but I think plain English, it's clear that non-resident is simply one who is not a resident.
Counsel, have you had the opportunity, to read Rodriguez?
I apologize, I have not. I'm happy to respond if the court
Well, let's say
would-
if Donald is abrogated, I mean, is this residency question really controlling?
So,
The
Your
issue
Honor,
in the case before us is a concession that Donald deems 131F, is it,
yes,
facially invalid. But
In
if
its
that's-
entirety.
in its entirety.
In its entirety. But if that's no longer the case, it's on the same,
Yeah, so the Commonwealth's position, and I apologize, I didn't brief this because I did not think it necessary, but for the Crowder issue, I don't think that applies to this case because the first part of Crowder says that it deals with cases in which there's insufficient evidence of licensure and then discusses what the remedy is. In this case, there was a plea in which the prosecutor stated that the defendant did not have a license. So we're not in an insufficient evidence world. Instead, I think we're more akin to the Bookman case, which is 492 Mass 396, 2023. And for that reason, I don't believe that the defendant would be entitled to a new trial if he was deemed to be a resident at the time of his arrest, given that the Commonwealth did state during the plea that he did not have a license, which in a plea hearing would be sufficient to support a conviction.
What do you say to defense counsel's suggestion that prosecutors should mention at plea hearings the defendant did not have a license in Massachusetts?
So, Your Honor, it would have been nice to have happened in previous cases, but frankly, given Donald and now I suppose Rodriguez, it's not necessary because I believe the statute has now been changed to be constitutional. That being said, obviously, more is better whenever you're giving a plea colloquy and a factual recitation, but this is not an element of the offense. And I do think it's important to emphasize that we are in a motion for new trial posture. And so it is the defendant's burden to show that their conviction should be upset. And for that reason, I believe they are required to show that they fell under the unconstitutional license scheme over the constitutional one.
Attorney Padalano, what is not an element? What are you saying is not an element?
The,
non-residency? Or
That you fell under 131F as opposed to 131, especially where the prosecutor did say he does not have an active license to carry. They did not posture that by saying only in Massachusetts or only in other states. Based on the record before us, the defendant had no active license to carry. Obviously, it would have been nice to have said everywhere, but that didn't happen here, and I think we can infer it. And quickly, I would also point out that if the court is tempted to remand with instructions, I would also advise that they remand with instructions as to who falls under 131, and I think 131D has a very good, clear definition of that. The only reason why I point that out is there was some testimony about the defendant working in Massachusetts, and that does have place of business as part of it. So if the court is remanding as to who falls under 131F, it would also be advisable to remand with instructions under who falls.
We should come up with a checklist of things that show residency in one state versus another and answer hypotheticals about somebody who goes to Florida every winter?
No, Your Honor. I believe that the only definition that is needed for the non-residency issue is what the term non-resident means in 131F. And that, I believe, is entirely able to be done with the Paul case and the inverse of it. Quickly, I would like to discuss the improper storage conviction. The defendant makes no arguments that should upset that conviction. In that charge, licensing is not an element of the conviction.
can I ask you, I don't want to cut off your argument, but realistically, so maybe resentencing? I mean, no one's pleading to a storage, no one's taking 18 months on a storage of a firearm unless it's tagged in or it's part of the minimum mandatory on the unlicensed, right?
So, Your Honor, I think that might make some common sense, but the Lewis case is quite clear that it's up to the defendant to affirmatively state that these pleas are connected. There's no ambiguity there. The Massachusetts case law is that if the defendant had wanted these pleas to be indivisible, that they would have to affirmatively have stated that on the record. They can get around that showing by stating that it was my intention during the plea negotiations that these were connected in some way. They could have submitted an affidavit. They could have gotten an affidavit from the prosecution that said, yeah, we negotiated this, right?
Do we think that's ever happened in the district court?
I think, Your Honor,
the defendant said these are divisible pleas?
I think the answer is that it doesn't happen in the district court because often they are not indivisible. Indivisibility is not the default posture. The default posture is that convictions stand on their own and that they are separate and should be sentenced separately accordingly. And I think that's the default posture that the SJC has decided, and that unless you show something to get away from that default posture, we should assume that they are divisible. Again, Your Honors, I would simply ask that this court instruct the trial court on the burden in a motion for new trial. And if the court has no further questions, I would again simply ask that the court affirm as much of the conviction as the denial of the motion for trial as relates to the improper storage and remand for factual findings on the issue of residency.
Thank you both. Very well argued by both sides. I want to add that we have the Rodriguez case, so it's unnecessary for either party to file a 16L letter. To the extent that we may wish supplemental briefing under Rule 22C2, we'll discuss the matter and issue an order with time and page limits.
Thank you very much, Your Honor.
So our next case is 2024 P959, Commonwealth versus THERON White. Good morning, counsel.
Good morning, Your Honors. Attorney Robert Pavento for the defendant/appellant. That's a tough one to follow. So this case is very similar to the case that was recently decided probably about 2 months ago, Quentin Smyth. The main issue in this case is if the evidence comes in, the only evidence that comes in is a person with a certain birth date, is that enough to show that that person does not have a firearm license? I think it's very clear that the date of birth was never stated. It goes to this particular defendant.
That seems to me that concept predated Smyth. I mean, if you're doing a subsequent offense trial, right, you at least have to tie him up somehow. It seems to me that that concept predates Smyth, that you actually have to tie the person to the date of birth and the name.
Well, I would argue it's a sufficiency issue.
Right. I'm agreeing with you.
Yes, okay.
In fact, I'm saying I think that you don't even need Smyth on that, perhaps on that.
Right, it's just, I thought it was kind of interesting that it came out like
Fair enough.
almost like yesterday.
Can I ask you a different question?
Yes, sir.
Put aside the probably less than adequate job that on the record-keeping end of it. What is a reasonable and natural inference from evidence, and I'm paraphrasing and it's a little less certain, but from evidence that the defendant is asked, having been arrested and with some obvious knowledge that they're going to charge him with carrying a gun that was in the bag, and given his Miranda warnings, asked, do you have a license to carry? Did he say in Massachusetts? Do you have a license to carry? And his response is, in effect, I have one in a different state. Why should a reasonable juror, in the light most favorable to the Commonwealth, not be able to infer that that means he didn't have one in Massachusetts? And if he did, he would have said yes.
I would argue when the defendant did testify in his own defense, and I think one of the last questions was asked, did you say that to the police officer? And he said no. So I think
right, but if we're taking this in the light most favorable to the Commonwealth, juries could certainly reject that. In fact, I suppose would the analysis would be that we would reject it, that we just take the light most favorable to the Commonwealth, which is that that statement stands on its own. So just humor me in on that narrow question. You know, as I said someone earlier, if someone said, you know, do you have any red balloons? And you say, well, I have blue balloons. What's a reasonable inference from that?
I mean, I guess it could go either way in that I said I had blue balloons, but I didn't say specifically I didn't have red balloons. You asked me a very specific question, and I answered your very specific question. It might be that we're splitting hairs, but I do believe it's a sufficiency issue, and whether or not we don't know what the jury considered. Did they believe the police officer? Did they believe the defendant? We don't know which elements.
No, right, but the question is, could any rational juror on the evidence taken in the light most favorable to the Commonwealth, which would mean to accept that the testimony was true, that he was asked whether you have a license to carry lawfully, and he said something to the effect of, well, I have a license from a different state. So with that, could any rational juror infer from that that response means he does not have a license in Massachusetts?
So if the jury believed the police officer that he stated that, whether or not, we don't know if he actually stated that.
Right.
If the jury believed the police officer over the defendant, I think it probably gets closer, but I still think that they still have to prove if the defendant has a license. An admission in and of itself is insufficient for a conviction. I know there's other evidence.
Well, the admission is insufficient, but I mean, the evidence that there's a gun, it seemed to me, is sufficient corroboration that, right, of that statement. I mean, the pretty big strike zone on what's sufficient corroboration for a statement.
Correct, Your Honor. I mean, if you read the transcripts, the officer says one story, and the defendant says a completely different story.
Fair enough.
Other than I was in a bike pursuit. That's pretty much the only thing they agreed upon.
Well, so the officer said that the defendant said he had a license to carry from a different state in the bag, and that wasn't located. The defendant then testified that he told the police that he had a license in his cargo pants. Is that testimony that about the cargo pants, does that show that the Commonwealth's proof deteriorated once the defendant took the stand such that the original testimony from the police officer was no longer believable? Sorry about the long question.
I'm sorry, could you say that again?
So the Commonwealth's case, ordinarily we consider required finding at the close of the Commonwealth's case and at the close of all the evidence. As of the close of the Commonwealth's case, we have the officer's testimony. He said it was in the bag. He said the license to carry from a different state was in the bag. That wasn't located. Then we have the defendant's testimony that what I said was that it was in my cargo pants.
Okay, I think it's twofold. First is, as we know, the defendant gets 2 bites of the apple at the required finding, after the Commonwealth case and after his case. Unfortunately here, we did not have the request. I think if you read, this is probably just me reading into it, the judge asks them, do we have any motions? And the defense attorney says, no. I kind of felt like the judge is saying, tell me something, but I know that's so.
Oh, but even when there's no motion for required finding, we consider the sufficiency of the evidence because otherwise it would be a substantial risk of a miscarriage of justice.
Correct. So I would say at the first step, when the Commonwealth rests, there was no evidence that that license belonged to that specific defendant. I don't see how it would matter if he says it's in my pocket, in my car.
So again, at that point, the evidence is, do you have a license? I have one in a different state. What's a jury to take from that?
I mean, if you take it literally, there's never the specific question. I don't have it, actually, oh my gosh. Right. Specific answer, I don't have it in Massachusetts. And then when the defendant testifies,
I mean, it's not really an issue of the case, honestly. It seems to me the case at the time of trial, right? The case was tried on a possession issue, not on a license issue, yeah, so.
No, I agree.
Which is why the record's kind of thin.
I mean, I don't think I could argue in any way that he didn't possess it, or that police arrested him, and whether or not the bag belonged to him, that was a question for the jury.
Right. I'm saying that was really the focus of the trial.
Yes.
And it looks like each of the parties gave on maybe a 3.5-minute closing on it, and it was kind of focused on that issue.
Correct, but in the same vein, if you have a trial, say, for assault and battery, the Commonwealth can ask one question: what happened? He hit me in the face. No further questions, I rest. That alone could prove the case.
Sure.
Counsel, how does it factor in that the jury instruction was whether or not, the element they had to find whether or not he had a valid license? It didn't say mass license or out-of-state license. Does that help your argument or hurt your argument?
Well, if I was going to use the attorney's argument from earlier, I would say help, but the Commonwealth still has to prove that whether or not he has a license in Massachusetts, California, whomever, that license belongs to that specific person. I don't mean to keep on saying this over and over again, but it is an interesting fact in that I don't want to say technicality, but it is a due process issue in that insufficient evidence was presented. I think I'm willing to bet this has probably happened in other cases where, what did you find today, sir? Joe Smith, on date of birth, doesn't have a license. Okay, no further questions. And no one said to the CJS officer, no.
But we've moved past that. Okay. We've moved past that, I think. Really, the question is without that? Is there enough evidence? And I'll let you speak to that, but your time is probably running short if you wanted to speak, if my colleagues have finished, about whether or not there was sufficient evidence that he knew the gun was loaded.
That's twofold. Obviously, if they don't get one, they don't get the two. And meaning if they don't prove count one, they can't prove count two. But as far as it being loaded or not, while it was a revolver, and while perhaps the jury looked at it, we don't know if the jury actually looked at it. There's no testimony that you could actually see the bullets in the revolver.
Was there in Silvello? Silvello relies upon the Commonwealth presenting the gun to the jury, and it didn't seem, in my reading of Silvello, that there was explicit testimony that looking at the revolver, you could see it was loaded. Is your interpretation different from Silvello?
I couldn't figure that one out. Obviously, the jury's not going to be able to look at the gun loaded. That's pretty obvious. We don't want the jury having a loaded firearm in this jury room. But given the benefit, so if we gave the benefit of the doubt to the defendant, for example, that the gun was his friend's, and his friend gave him the bag, he would not have known that the gun was loaded, unless his friend said, "Oh yeah, I gave you a gun, and the gun's loaded. Don't drop it." You know.
So on that, and again, not to parse it too much, but if we're considering the evidence as we must in the light most favorable to the Commonwealth, we really don't necessarily give the defendant the benefit of the doubt on this analysis. And
No,
the jury
no,
certainly could have, but apparently didn't.
No, I understand and I agree. It was a strange case in that it was all over the place. And there was no specific evidence from anybody about was the gun loaded, other than when the billetician said, I put a round in it, I pulled the trigger and it went bang, basically. I think my best argument is in the beginning, where they never stated that this specific person with this specific date of birth does not have a license. And I remember from the, for example, the Smyth case, I forget which justice asked, he goes, even look it up, this person's name is Smyth. I mean, the odds of, this person having the same date of birth, I think is pretty high.
I think you won that
Quentin?
part of it, yeah.
Quentin?
Yes.
His first name is Quentin Smith.
Yes, his last name is Smith. I think the judge said, I can't remember her name now. I watched it yesterday.
I have a question for you about the Smith case. So are you arguing that the lack of evidence of the date of birth entitles your client to a required finding under Smith? Or are you also requiring that the lack of evidence of the date of birth meant that the CJIS printout was not admissible based on the testimony here?
I think as in the Smith case, so long as the individual who testifies can talk about the maintenance, how they get this information, some type of foundational requirement, other than I have a piece of paper that says, THERON Smith, date of birth. It'd probably be helpful if that piece of paper had like a social security number, or where he lived, or his eye color even, something. It's, I think, a little strange that a firearm licensing only has name, date of birth, nothing else, no address.
If they had a booking officer who came in and said, well, we booked him and he gave us that date of birth, would that have been enough? Same name, same date of birth. Is that enough? I mean, they didn't, obviously, but.
I think it would be a defendant's statement, so I think we're coming under the defendant's statement.
No, just as a matter of sufficiency of the evidence. My question is, if they had someone come in to say, well, this defendant's date of birth is XYZ, and that's the same date of birth on the CJIS document, would that have been enough?
So long as the CJIS officer testified that is the date of birth.
Okay.
Yeah, I just wanted to be clear in your position. If for instance, in a hypothetical, similar to our case, but the police stop the defendant, and he says, and they ask him, they find a gun, and they say, do you have a license? And he says, I do not have a license. Would that evidence be sufficient to survive Lattimore? It's a sufficiency question.
No. No, Your Honor.
I see your time is up. Your argument was very helpful. Thank you.
Thank you.
Welcome to the Appeals Court.
Thank you. Good morning, Your Honors. May it please the Court, ADA Lindsay Conkey with ADA Aaron Knight, asking this Court to affirm the defendant's convictions, where the jury could reasonably infer from the defendant's affirmative claim of having an out-of-state license and his overall behavior that was inconsistent with legal possession did not, in fact, equate to him having a license at all. I will jump in quickly just to answer some questions that you asked my brother that I think would help clarify. As Officer Fennessy testified, having an out-of-state license would change this because there is no reciprocity. So even if he had been able to produce an out-of-state license, which he was not, that would not have made him legally able to carry or
Your
possess.
witness was a bit uncertain about the reciprocity.
Officer Fennessy? I don't believe so.
I believe Officer Fennessy testified he wasn't sure about reciprocity. Then there was a follow-up question. He testified if somebody had an out-of-state license, it wouldn't be valid here. But
I'm
as to
not
the question of
sure.
reciprocity, I thought he said he wasn't sure.
I would have to double-check the transcript. However, I would also like to remind you that an out-of-state license was not found. So there's no evidence that he possessed the out-of-state license anyway. But I would have to double-check to see specifically what he said regarding reciprocity.
Focusing on this, I'm sorry, did you want to go? Yeah. Just if you could focus on the CJIS for a moment. And as I asked earlier, I mean, take Smyth out of it.
Right.
How does that possibly identify the defendant as the same person in the CJIS? I mean, as I tried to kind of get to, even, I mean, if you're looking at a subsequent offense trial, right, at the very least, you have to have name and a date of birth in some document or some testimony that the date of birth of the person sitting in the room is the same date of birth as the CJIS or the other document, right?
Right. And
Was
for
there anything here on that?
in terms of the date of birth, no, there's nothing on the record about how they acquired his date of birth. And I know you said to
Not
take-
his date of birth, the fact that it is his date of birth. You
Right.
have a document that has a name and a date of birth,
Right.
okay? The name we'll give you, because people testified to what his name was. But was there any testimony or any document or any shred of evidence that that date of birth that was on that document was the same date of birth as the man who was sitting in the courtroom?
Not to my knowledge, but I know you said take Smyth out of it, but this isn't Smyth. So
Right.
we had more than just the CJIS record. So we don't need to rely solely on the CJIS testimony that the report came back with no record
So
found.
what value then does the CJIS record have, if any at all? Is there any value to that evidence?
Sure, the lack of reciprocity.
No, that's again assuming it's the person who's sitting there. But if we,
Well, I believe that he also
if we take out
testified
the
that-
fact that, if we assume for the moment that there was no evidence that they're the same person,
Correct.
then
Well, we
what
still
value does
get
it have?
the educational experience that there's no reciprocity between New Hampshire and Massachusetts, such that if the defendant, even if he had been able to produce the out-of-state license, it would not have gotten him off of this charge.
Sorry, go ahead.
I'd also like to address one of the other questions, which was whether the revolver was loaded and whether they could tell. In Exhibit 4A, if you look at that, you can see a picture of the gun when it was recovered. And I know it's only in black and white. Unfortunately, it was not entered in color. But you can see that the rounds are peeking out of the cartridge. So the
Sorry,
jury.
that's at Record Appendix 31?
The page.
3?
30, I believe it's 31 is 4A. There's several photos, but on 4A, the first photo.
So you're saying on 4A at Record Appendix,
Sorry, I need to turn around.
I think that's 4A, 31, you're saying the bullets are visible?
I believe you can see them peeking out, yes.
So you're saying if you zoom in, those little ridges, that's a side view, just one on the same picture, that's a side
Correct.
view.
And then there's also a more like zoomed-in version on 4C before the rounds have been removed, and you can see that they're in the barrel. I apologize if my gun names aren't the correct, but.
Okay.
And so those were all given to the jury. And then, so in terms of them being able to tell that it was loaded, and in terms of the defendant knowing, as you mentioned in Silvello, Resend, all of those, that there's a reasonable inference that somebody would check to see if a gun is loaded before putting it on their person.
All right, let me ask you this then. This statement, and that's transcript page 96, they demanded his license to carry, which is what you do to see if a person has a license to carry, if you can carry it lawfully. He said something to the effect of he had a license to carry from a different state in the bag that wasn't located. Why is that enough? Why that, if we just take that in isolation, why is that enough to survive a motion for required finding?
Well, there was no motion for a required finding.
Okay, why is that enough, given the fact that what we're doing here is trying to determine whether there was enough to survive a motion for required
Right, well,
finding?
so, I mean, questions of credibility are left to the jury, and so the officer testified that he had said that. I believe he said that the reason he said something to the effect of was because it had been a long time and he didn't want to say something that had been said verbatim that wasn't what it ended up being, but that the intent or the content of what was said was the same. And that is in line with what the other officers testified to him saying as well. And even the defendant said that he had a license, just in a different location, so.
So just be clear, are you conceding that, or in your own words, what is the evidence that survives the Lattimore challenge that he had a license?
The defendant's own admission, the affirmative claim of having the out-of-state license, and then I think you can also take into consideration the flight. He led them on a fairly extensive chase, went through a baseball field, which suggests consciousness of guilt, and he said he had the gun and the license before it was actually recovered from the backpack. It wasn't until he got to trial when he changed his story saying that he had never said any of that.
I'm not sure flight is necessarily. People have all sorts of reasons to flee from the police.
On its own, I would not say that that is enough, but I do think that it lends to a consciousness of guilt. And we have Grayson and Booker would confirm that.
They weren't given, nor was any instruction requested on consciousness of guilt, right?
I'm sorry?
On consciousness of guilt.
Correct.
Okay.
So if there are no further questions of Commonwealth.
I do have, I'll pose to you the same question I posed to your brother counsel about Silvello. It's really unclear to me whether there was explicit testimony. It would have been hard to have testimony from one of the many police officers testified saying, you can see in this revolver, you can see the ammunition, the bullets inside it. And it was given to the jury, but also had a zip tie through it. So it wasn't like the jury was able to close the chamber and see that you could see the bullets. So I'm just wondering, do you think Silvello stands for the proposition that if you have a revolver and the jury is able to see that revolver, then per se you can tell, you can infer, you can decide from that that a person would be able to determine whether or not it was loaded?
Yes, I believe circumstantial evidence, so including external characteristics, can be used to infer that a revolver is loaded. And given the extensive case law that is held that the external characteristics of firearms, revolvers specifically, would indicate that it's loaded, then yes, I believe that a jury could reasonably infer that.
And the fact it was in a sock and a backpack, that doesn't help your argument, but you claim that there's still sufficient basis that he would have known, he would have been able to see that firearm.
Yes, because of the fact that, as they say in, I'm sorry, I'm forgetting the site exactly right, Resende and Silvello as well, that somebody, a reasonable person would check to see if a gun is loaded before putting it on their body. And I understand this is not a waistband, but it is a thin nylon backpack on his back, which is not somewhere that you would want a firearm to discharge. So you would reasonably check to see if that is loaded before putting it there.
The court in Grayson didn't find that. The court
Correct.
In Grayson, and what's the difference with Grayson in our case?
I believe in Grayson, I I'm not sure, I'm sorry. In Grayson, I cite that for flight and not for the inference that it's
I
loaded.
think Grayson found the flight could be attributed to him possessing the firearm, but not the ammunition. But he allegedly, he took off, threw the gun, they found it in a sock, tied up, and they said that was insufficient.
Okay.
But he had it in his waistband allegedly. So it's similar to, your theory that because it's on his person, he would have more likelihood of knowledge that it was loaded. So that's why I was asking you to distinguish.
Right. I'm not sure because I don't know all of the facts that you just put out there. I would say that just because they didn't explicitly say it, did they discredit that in their opinion, or
Discredit what?
that having it been on his waistband he wouldn't have checked, or just they didn't find that?
They just found it not sufficient.
Okay.
It also wasn't a revolver, which could be distinction.
Thank you, counsel. I think we understand the arguments. It was very well argued by both sides. One practice tip, as you can tell from both the first two arguments, we love 16L letters.
Okay.
And so when a case comes down that's relevant, even if it might be interpreted to help the other side, we really like to get 16L letters before oral argument.
Okay. All right. Thank you.
And thank you for filing one, counsel. So the next case is 2024 P505, Commonwealth v. Alex Manuel BRITO. And I understand that the appellant's counsel has waived argument. Ms. Slyman, do you wish to be heard?
Yes, thank you, Your Honor. I'm sorry, I'm just waiting for the clock to start. Thank you. Good morning. May it please the Court, Mackenzie Slyman on behalf of the Commonwealth, asking this Court to affirm the defendant's 2 convictions for assault and battery with a dangerous weapon in this case. First, the trial judge here properly allowed the Commonwealth to introduce evidence of 2 prior convictions of the defendants pursuant to General Laws, Chapter 233, Section 21, for the purposes of impeachment. That was not an abuse of discretion by the judge. First, the 2 prior convictions, one a 2016 charge out of BMC Central for distribution of a Class B substance that was pled out that same year, and the second, a 2018 charge for the same charge for also distribution Class B subsequent that pled out in 2022, both comported with the requirements of the statute that they be felonies where the convictions were within 10 years of the date of trial. Second, they were sufficiently dissimilar to the charges that the defendant was on trial for, being 2 drug offenses, where these, the 4 charges the defendant was on trial for were assaultive in nature. And lastly, in an abundance of caution, I would put forth, the judge did give contemporaneous limiting instructions, strong limiting instructions to the jury as to the extent to which they could consider those prior convictions. I would also note that the prosecutor made no mention of them in her closing, and the defendant, via his own direct, strategically, and I think in at least part successfully, got ahead of it by getting the prior convictions out in his direct examination. If there are no further questions on that particular issue, I'll move to the second. As it relates to witness Alan Valerio's passing, mentioned that the defendant during the altercation stated that he had been to jail before. The fact that no curative actions were taken in relation to it because it was not objected to did not constitute a substantial risk of a miscarriage of justice here. First, the defendant was not prejudiced by that testimony. I would point most directly to the fact that he was acquitted of the 2 most serious offenses. Frankly, overall, there was really no dispute that the defendant had physically committed all of the acts that were at issue here. It really came down to, with the assault with intent to murder, the assault issue there, and then the intent issue there, and then in relation to the self-defense, defense he brought up. So he wasn't prejudiced by the testimony. In fact, it really gave context to excuse me, and it was given further context by the appropriately allowed in prior convictions after the fact. Again, this was a strong case for the Commonwealth. There were 6 witnesses, including the 2 victims, that testified about the defendant's behavior with the knife, and the incident was caught on video and presented to the jury. And lastly, this was clearly a tactical decision by defense counsel to not have attention drawn to it. There was an immediate sidebar after the witness made that statement where defense counsel asked the judge not to do anything, and we can revisit it at the close of this witness's testimony. At that point, defense counsel reported that he had consulted with the defendant and that they were asking that no attention be drawn to that statement, which the court acknowledged was in line with and consistent with trial counsel's strategic decision throughout the trial. So for that reason, there was certainly there should not be any serious doubt that even if that statement was admitted in error, that it would have materially affected the trial or that the outcome would have been different. And if there are no questions for the court, I will rest on my brief.
Thank you, counsel.
Thank you so much.
If the parties are here, we'll take one more case before the break. Is that okay with you?
Yeah, let's do it.
And so the next case is 2024 P 1356, Evolving Properties LLC and another versus LIANN DIMARE and others.
Yeah, there we go.
Good morning, Mr. Curran.
Good morning. May it please the court, Dana Curhan for the appellants. Let me start by conceding that I get the dates wrong as far as the motion for directed verdict. It was actually an oral motion that was decided before the jury came back with its verdict. So, and then there was a written decision that came out afterwards. Now, that said, you know, I contend that the trial counsel got it right and argued that there was no support for entering a directed verdict. I think, I mean, he actually made 2 points. There was the loan contract and the actual contract for the real estate were inextricably intertwined. I don't think you can have one without the other. What happened was originally there was a proposal that
Can I actually
Yes,
jump in with a
of
question?
course.
So your client's claim is that the other side forced the breach?
yes,
Okay. And that could have been a special question to the jury, right?
Could
It
have
been. And it was not.
it was not.
And then once the judge renders his verdicts, and then you get a jury verdict that your client or would presumably understand would be inconsistent if that's the theory, could that not have been cured at that time by saying, hey, can we just make sure the jury isn't saying that that they forced the foreclosure here by their behavior? Can we give them a special question, and now that they're still here, before we discharge them?
They could have. I
A
mean,
little odd procedurally, no doubt, but.
It is odd. I mean, I don't have a problem with what the jury did, actually. I do have a problem with what the judge did in allowing a directed verdict, because essentially the judge said, viewed in the light most favorable to Kim in Evolving Properties, the evidence cannot support a finding or establish as a matter of law that she defaulted on the loan. So, but if she defaulted on the loan because she was forced to default on the loan, then that's not grounds for a directed verdict.
So that's why I'm asking, just on the issue, if you will, of waiver, why should that not have been resolved right then and there before the jury's gone? And say to the judge, well, wait a minute, I think the jury's saying something different than what you just told us. Can we just clarify that, please? And then the judge might or might not have said, oh, okay. And then if the jury came back and said, oh, yes, we're saying our verdict is based on the fact that Dimare's behavior basically forced a breach, then there we go. And then the judge would say, oh, okay. And then
I guess my position is that the jury necessarily found that she forced the breach because if, LIANN did not contribute what she was supposed to contribute to the renovations, but that's probably a small portion of the $91,000.
So you're basing it solely on the money, right? Because you do concede in your brief that the jury could have decided this the way they did based on other conduct, such as the failure to contribute to the renovations and the carrying costs.
Yes, but the $91,000 cannot represent just those facts or just those particular points because it did not take a lot. LIANN was responsible for half of the carrying costs and half of the renovation costs, but they weren't that much. They weren't $91,000. I think what you have to look at the jury's verdict as saying that also includes forcing a default.
Well, what do we do with the fact that the plaintiff's counsel in closing was talking about I think it was $78,000 that the judge and the judge interrupted and said that's outrageous, or words to that effect. Is there are you arguing that the judge improperly sort of corrected for that with his verdicts?
I'm not sure if he corrected for that because, again, the directed verdict was issued before the jury deliberated, and I think the $78,000 had to do with her attempt to purchase the property at auction. So I don't think, I'm not sure, but I don't think that had anything to do with it. The difficulty we have is that, trial counsel kind of jumped in at the last minute. He was in a little bit over his head. I think he did a good job in getting the jury verdict. And I think the jury verdict does, it really has to reflect the forced breach. Now, so what I'm really arguing is that the judge, when he says this is a separate contract and it has nothing to do with the real estate contract, the original contract, the parties agreed that LIANN would pay $200,000 to Kim, half of it representing her buy-in to the property and half of it representing a loan at 14%. She then later said, well, you know what, I'm going to convert the whole thing into a loan for $200,000 at 15%, and you owe me some points. But then at other times she said, but I'm still a 50% partner. I'm not just a lender. So it's a little strange, and it's kind of hard to figure out. And the parties did a lot of things without lawyers, which is why I end up here so often with cases like this. But I think,
if the jury's verdict reflected, theoretically, only a breach based on the failure to contribute to the renovations and the other carrying costs, what is your position as to what's the max they could have come up with on that?
I don't know. I'd have to look at the numbers. It's probably less than half of that.
Okay, less than half of the 91.
Less than half of the 91. And so, when you look at, so the two contracts are intertwined, and I don't think you can look at one without the other, but I think as a defense to the default, I think there was overwhelming evidence, at least when viewed in the light most favorable to Kim, that LIANN forced the default. She said she wouldn't give her a payoff figure. If she had given her a payoff figure, Kim could have gone to a lender and said, this is what I need. I don't care what terms you give me, this is what I need. Or if the property could have been sold, that would have paid everything off. But Leanne would not give her a payoff figure. Came up, she said, well, I think maybe you should sell it for a minimum of, I think, $285, which was probably above market rate, and here's some conditions I have. But she never ultimately agreed to any of that.
Why couldn't she do that? Why couldn't she? I mean, she's got pretty good skin in this deal. Why can't you say, well, okay, great, go sell, but I'm not, let's not sell it for, 2 cents on the dollar just because you're jammed up. Let's get, this is what I think it's worth, and this is what I think we should get.
Well, I suppose she could have listed it at $285 or whatever that number is, and maybe an offer comes in below that, and maybe they then have that conversation. But she ultimately didn't allow her to list it. And that's the problem, because she couldn't sell it. She didn't have a payoff figure, so she couldn't go borrow the money. And, ultimately, I think it was 9 days after the default, they said, hey, you're in default of the loan. And that's a real problem, because I think when you're looking at a directed verdict standard, that is, there was evidence, there was substantial evidence viewed in the light most favorable to Kim that it was a forced default. And again, I think, so you do have probably 2 inconsistent verdicts, even though the judge ruled first and said, there's no forced default, and the jury said, yes, there is a forced default, and the judge allowed that verdict to stand. There was some discussion about it after, in the post-trial hearings, but I think ultimately, that it's really the judge's directed verdict that is a problem in this case, and I ask that that be reversed. Unless there are any further questions, I'll leave the remaining points to the brief.
Thank you, that was very helpful.
Thank you.
Counsel?
Good morning, Your Honor. May it please the Court. Peter Calabresi for the appellees, LIANN DIMARE and Lily Pad Properties. As Your Honor has mentioned earlier, there was a waiver of this inconsistent verdict issue for appeal. There was never any objection to the directed verdicts when they were rendered. There was never any objection to the jury verdicts when they were rendered. And in fact, the parties had agreed on what claims would be presented on directed verdict. Both parties moved for directed verdict on breach of promissory note. Both parties waived written findings of fact and conclusions of law vis-a-vis the directed verdicts, and they agreed that they wanted the claims decided on directed verdict decided before the jury rendered its verdict. That was actively discussed by counsel on the record.
It seems like all the cases, probably because it's an odd procedural construct, but it seems like at least all the cases I could find that go to talk about inconsistent verdicts and waiver go to situations where a jury is being asked to reconsider its verdict based on, usually it's a conflict between the special verdict questions and the general verdict, right?
Right.
Are you aware of any case that says that we can find waiver under these circumstances where the judge renders jury waive verdicts, jury does verdicts, there may be some inconsistency, but you want to go and challenge the judge's decision? Why do you need the jury to stick around, and why can't you then just raise it down the road?
Sure. I believe the Service Publications case that we cite is a case with a mixed bag of jury verdicts, directed verdicts, judgment notwithstanding the verdict. I would direct the court to that. Both parties reference that case. I would say that the equally important point in this case is looking at the jury instruction that the parties agreed to and what was given to the jury. The parties specifically agreed, after a long colloquy, that this issue of a sale of the property being part of any agreement that they had was not going to be part of the jury instruction. That was never, there was no evidence for that at trial. There was 6 months of emails that are an exhibit in the record appendix where the parties are trying to agree on how to sell and whether to sell and all that kind of thing. That is explicitly agreed to by the parties to not be part of the jury instruction. And if you look at the verdict slip itself, the verdict slip tells us what the $91,000 in damages are for. It's for renovation costs. And if we look at that, just have a moment here. It's right on page 1 and 2. It tells you exactly what the damages are for. And, you know, my clients don't necessarily agree with the number, but there's no guesswork needed to figure out what the jury thought the damages were for. There was no implicit finding of a force breach in this case due to this promissory note issue, because if you look at the jury instruction, Your Honor mentioned the exchange during the closing arguments where the trial judge said, counsel, what you just said was outrageous, that whole exchange. The $78,000 issue wasn't to do with Ms. Mulligan buying the property. That's how much she had paid on the loan as of that time. So that was strictly a loan issue, and the judge knew that. All the parties knew that. And the judge jumped in and corrected counsel at a sidebar, and then counsel came out. Counsel was at the sidebar, Counsel Berger, for the appellants, and he told the judge, I'm sorry, why don't you strike that? You can instruct the jury to strike the reference to the note and the $78K from the closing. I'm not seeking that. I'm sorry I made a mistake. That was essentially what it said. Mm-hmm. And the judge did that. And the judge came back on the record with the jury and told them the promissory note claim is not before you. I've already decided that. Everyone knew the promissory note claims were resolved the day before. I don't see how one can find an implicit finding on an issue that the jury was explicitly instructed to not consider, and it wasn't before them. That's what we have.
Can you give us a sense as to where the 91, I mean, we can't speculate on numbers. Jurors come up with odd numbers all the time. But this one at least bears some connection to some of the evidence, as Mr. Curran has pointed out. Can you give us just an alternative thought as to where 91,000 comes from if it's not what was left over on the note?
I think it was a mistake. My personal belief, of total speculation, is that in Appellee's closing argument, this figure of $91,000 was talked about, but it had nothing to do with the appellants. It had to do with the lost use and occupancy money that appellees were due from Ms. Mulligan, who had occupied the property for free from 2019 all the way to the day of trial. So that number, if you just did a Control F search of the transcript, 91,000 and change comes up one time when I am speaking to the jury about the lost rental use. And we talk about this issue in the brief at the latter parts of the brief. So that's where that number comes from. I think they just made a mistake. But with the actual monetary amount, that the monetary amount itself isn't an implicit finding of anything, because when they were instructed by the judge, it was clear the sale and promissory note issues were not before them. It wasn't silence. This was explicit instructions on those issues. And the verdict slip itself, at the very top of page 2, it says, if you answer question 2 and include damages for the cost of renovations, do not answer questions 3 and 4. Go to question 5. And they did precisely that. And no one objected when they read that verdict. And what's also instructive is, if you look at the supplemental appendix that we filed, there was a motion, I believe it was allowed in the supplemental appendix as a few-page document, which was a trial memorandum prepared by appellant's counsel. And this came about because the trial judge, you can see this on the record, says, I don't know what your breach of contract claim is. It's evolving, it's amorphous. You need to write it down. So he gave him some time to prepare this memo. And when you read that memo, it is silent about this force breach issue. It has nothing to do with this force breach issue. It's not even mentioned. And that was the claim the jury was pursuing. That was the evolving properties breach of contract claim. And there was no forced breach of a promissory note. The promissory note was an unconditional promise to repay a sum certain by a definite time. And that definite time was either upon the sale of the property or within 1 year from the date of the note, whichever first occurred. What occurred first was the 1 year period. There was no requirement in that note for payment to only come from sale proceeds of a property. The borrower was free to pay that note off however she chose. She chose not to pay. She had paid $0 towards the note as of the maturity date. And that was admitted pre-trial. There were requests for admissions that the court then allowed. It's Exhibit 10 from the trial, where there were admissions of fact. It was an admitted fact that there was a promissory note breach, no payment, and Ms. Mulligan, who's a real estate professional, was asked specifically about this at trial, and she knew that the result of failing to pay the promissory note could result in foreclosure of the mortgage. There was no surprise. This was not unsophisticated parties dealing, not knowing what they were signing. The appellants...
Can I circle back to the 91,000? So once you see the 91,000, right, there's no request for JNOV, that no one at the time says, hey, Judge, that 91,000 doesn't correlate, you got to fix it on the number, right? And you don't file a cross appeal.
No, we didn't. And I can tell you why, if you like.
Yeah, please. Yeah.
To keep life simpler.
Yeah. So I guess simplicity is, I'm a fan of simplicity,
Yes.
but then how do you not waive the argument now that we ought to adjust them? We ought to adjust it.
I wanted to put that out there for the
Okay.
court to consider, because it was a mistake.
Fair enough.
With the figures, but my client has been dealing with this since 2017, and we were happy with the outcome overall, so we said we're going to keep this as simple as possible.
Thank you.
The other thing I would add, and I'm happy to answer any other questions, is there is no inconsistency between this jury verdict and the other directed verdict claims, wrongful foreclosure, breach of promissory note, and the like. And the other was the breach of the foreclosure memo, where Ms. Mulligan was the buyer and then failed to perform. The jury found $91,000 for renovation damages. That's what they found. The obligation to repay a promissory note, which is an unconditional promise to repay, is a separate and distinct obligation. There's no loan agreement. There's reference in the appellant's brief to, quote, a loan agreement, which does arise in some contexts where there's this parallel agreement with the loan. We don't have anything like that here. I'm happy to answer any questions, but I would rest on the brief.
Thank you. Very well argued by both sides. The court will take a 15-minute recess.
Court, all rise.
is open. Please be seated.
Good morning. We will continue with the next case, which is 2025 P458, Department of Children and Families and Another versus Father and Another. And as I'm sure experienced counsel knows, this case is impounded, so I would ask you not to refer to any of the parties by name. It's fine to say child, mother, father, older sister, if that's relevant. So thank you very much, and with that, we'll hear from counsel for the father.
Thank you, Your Honors. Excuse me, I'm Attorney Diana Spanos on behalf of the appellant father. From day one, Your Honor, from the day of this child's birth, the father had nominated his sister to step forward. He found himself in circumstances where he was not able to take custody of the child, and he elected that she be considered.
Considered for what? Was there an adoption plan involving the sister?
Well, at that point in time, he was hopeful that it would be kinship. And in truth, I know the child argues that this is not a competing plan case because he only wanted kinship. But the judge did find it was a competing plan case, and the judge did find that the sister was willing to adopt if that was necessary. Under the circumstances, adoption of Dora is the leading competing plan case, which requires that the court must take meaningful consideration of both plans and pick the alternative that suits the child's best interest. And that just...
In the best interest, what about the delay? First, is it reasonable for a four-month delay to get a birth certificate?
No.
Couldn't they have just gone and gotten one?
Thank you, Your Honors. No, it's not reasonable. And even with the Social Security card, is it reasonable that 8 months went by and they weren't able to get a Social Security card? I'll make one other point. They wouldn't permit the aunt to visit in person with the child for reasons that weren't quite clear. I mean, I know in policy the DCF usually relegates visitation to the parents and maybe a grandparent, but to not allow her to visit knowing that she was interested in taking custody, But she was there for the long run. I mean, her testimony was, I'm here, this is my nephew, I want to care for him.
Is there anything in the record prior to the aunt's testimony at trial that DCF knew that the aunt was putting herself forward as an adoptive resource?
Yes, I believe it's even in the 51B investigation. And I mean, at the hospital, the day that they did the removal, both mother and father were in favor of the aunt taking custody. So there's no, and I mean, yes, they did know, because I believe there's also testimony that, no, you're right, I think it is the aunt who testified that she had spoken and somebody had told her, we're waiting on the Social Security card, and she said, okay, that's understandable, as much as I don't think it was understandable.
But you would admit there's evidence, or you'd say there's evidence at the hospital, but the father failed to appear at the custody hearing.
Yes, and I know the judge...
That would have been a good time to raise that.
I'm sorry?
That would have been a good time to raise things of that nature.
At the hospital?
No, at the custody hearing.
At the custody hearing. There's also no evidence that father was served before the custody hearing, and neither parent was served. And then they delayed the hearing for 3 weeks, and still there was no evidence that either parent received legal notice. In fact, father wasn't served legally until June, I believe, of a month before the termination trial.
He was haved in.
Yeah, and he was haved in. And the court learned, so I know the department argues, I'm jumping ahead a little bit, the department argues that the judge did make reasonable efforts findings at the temporary custody hearing. She made a finding on the first day and then the second day where the parent's father's rights were waived. And then doesn't make another finding until her final findings after the termination. And then makes one more finding like 6 months later, which really isn't relevant because dad's rights were already terminated. But getting back to adoption of Dora and the competing plan case, it's my position that that is the prevailing argument. I know the department raises an unpublished case, adoption of Judy, and I think that case is easily distinguishable. In that case, the child was born in May of 2017, and entered the pre-adoptive placement in August of 2017. Trial began in May of 2018, was delayed for many reasons, and on February 2019, the parents stipulated. And then father raised his competing plan of his own sister versus the pre-adoptive family. So the judge in that case, father was asking that there be a delay to allow the ICPC to be processed. And the judge heard from argument and made a finding that the aunt would have passed the ICPC regardless. So he or she began with the presumption that both plans were viable. And then both the pre-adoptive family and the aunt testified, and the judge found that the child was integrated into the family, and the paternal aunt, unfortunately, had not even met the child yet. So based on what the judge found as an extensive evidence of a strong bond between that child and that pre-adoptive family, he went ahead. And when he made the finding that the aunt would pass, he said, if that's the case, I'd hold off until we could legitimately do that. But in this case, that just didn't happen. Rights were terminated, and the judge oddly makes a finding which really misstates the current law, that should the department choose this home, then the child will be allowed to argue at a subsequent hearing, but not the father. And that's just not the case law.
Can I ask, so at the outset, we talked about the parents wanting the aunt to come in. What do we do with the judge's finding that there was no indication that the aunt was actually ready or willing to take custody of the child? Which is finding of fact number 9. It says, no indication that the father's aunt was able or willing to take custody of the child, or that the father had even talked to her about it.
I think that that's not accurate. I think there was evidence. The department knew that there was evidence. Now, they couldn't have done that without the ICPC. And what I also find interesting, and it's late and not an appealable issue at this point, but had the department waited at least until the second day, the aunt could have come down. There would not have been the need for an ICPC, but they jumped in right away, and that's what triggered it. There are plenty of parents that struggle and have a hard time, and just because, and they're allowed to nominate a caretaker for their child, but just because DCF files a petition, that parent loses that right, and this whole other process, comes into play, and that is unfortunate. I didn't cite this case in my brief, but I have informed counsel about it. I think it's relevant. The petition of Boston Children's Service Association to dispense with consent to adoption. It's 20 Mass App Court 566. It's an older case, 1985. The relevant pages are between 571 and 573. It involves a mother that was incarcerated for murder, and she was incarcerated for life. And yet the court found that her incarceration alone does not necessarily mean her unfitness. And she was able to elect her mother to come forward and take custody. Father was just really denied that opportunity. And, a parent gets themselves in trouble and they need time. Even in a regular care and protection case, the department is supposed to provide them with the opportunity for services. And that didn't happen. Now, granted, father did get arrested in April, and that is unfortunate, but prior to his arrest, he had signed up for parenting classes, substance abuse classes, anger management. They had literally called him the day before his arrest to come in, and then, of course, when he was arrested, he couldn't do it. But then he got into jail, and the department never once contacted him. And the judge did make a finding that they learned in April that he was incarcerated, and yet even then, the department didn't come. He asked for a visit. The department, by their own regulations, they're supposed to go in and maintain contact. And the judge makes a finding that father failed to visit with his child after his incarceration, and I argue that's just not correct. The judge made, several findings. A lot of the court's findings are based on statements the father made at the hospital during his birth. She blames him for not being able to meet with the department outside of his visit, but recognizes that he did have a housing issue. But in many cases, the department will say, let's meet at a McDonald's or something outside of the visit, so they have that opportunity for one-on-one outside of the visit. The judge, I mean, really kind of looks at it as though he refused services or he was unwilling to take services, and that's just not the case. And the statute, Chapter 210, Section 3, requires the judge to make findings regarding her conclusions, and unfortunately, all the judge does with her conclusions regarding reasonable efforts, she has no findings to support them. And I know that the department goes back and says, well, this is in the record, that, you know, all of these things, but that the judge is required to make findings to support her conclusions, and that's just didn't happen in this case.
Are you arguing that reasonable efforts on the part of DCF would have required telling the father when the ongoing social worker left DCF's employ?
Well, I believe on the service plan, or the action plan, they call it now, the department is required to meet monthly with the parents. And when a parent is incarcerated, it's even more difficult for them to access services. So it should be even more important for the department to maintain some kind of contact. And for the judge to make a finding that the father failed to maintain a connection with his child, and yet he's in no position to have a visit unless the department steps up. And I would argue the department really dropped the ball here. And a lot of this is related to...
What do you say to the argument that he waived that claim by not raising it while the case was pending?
Well, and I was just getting there, Judge.
Okay.
This case went from the child's birth to termination in 8 months, and that is lightning speed. I've been practicing child welfare law, I hate to say this, but nearly 30 years. I've never seen a case go to termination in 8 months. It's even somewhat unusual to see it go to permanent custody in 8 months, but termination? The department didn't even have an opportunity to hold a foster care review, which they're also mandated to do every 6 months. That's the best opportunity for hashing things out. The parents are invited, their attorneys are invited. That's where you find out what's happening and have an opportunity to raise it. But 8 months was just lightning speed, and it didn't happen. So unless there are any additional questions?
The general finding or conclusion of the judge, essentially she concluded the father abandoned the proceedings and only came to court because he was haved in. What would you say to that, or what do you say to that?
I would say that the judge is speculating. She doesn't know that. I mean, legal.
What is there a burden on a parent to actually go to court? As the judge found they were instructed to go to court, they're instructed to get an attorney, and they just didn't. That's what the judge found.
And the day that that happened was the day of the removal, which granted, the father did kind of lose it, for lack of a better, phrase. But this was his first child, and he just learned that he was losing custody, and, the mother had been using drugs. I mean, there were various reasons. And in anger, he walked out and then, wasn't allowed to come back, basically. Who's to say he really heard or what he heard that day? It was a very emotional day, I'm sure, for everyone.
Is it in the record? I'm pretty sure it's the case, but he didn't request to be haved in. Is that right? That the court just brought him in on their own accord?
No, mother, his attorney
Or his
requested.
attorney?
Yeah,
He did. Okay,
that
sorry, I
is in
missed
the
that.
record.
Thank you for clarifying that. Sorry.
And without any further questions, I will rest on my brief.
Thank you, counsel.
Thank you.
Now, I understand that you're splitting your time with 10 minutes for DCF and 5 minutes for the child?
That's correct. Yeah.
Good morning, Ms. Braithwaite.
Good morning. Members of the panel, may it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the decree issued by the lower court terminating father's parental rights. Father is a violent man, a violence that often leads to arrest and incarceration. He's unable to manage his anger, and his lack of self-control resulted in the child's first days spent exposed to conflict and escalation, where even the hospital wasn't safe, and security was required to intervene on more than one occasion. Father has demonstrated a profound lack of understanding or insight into what the child needs or how to take care of him. And rather than take steps to address any of these shortcomings, Father avoided the department and Father avoided the court at all costs for the entire duration of this care and protection. The evidence put before the court demonstrated both Father's unfitness and its ongoing nature. The court was operating well within its discretion to find that it was in the best interests of the child, who had spent his entire life in foster care, to be freed for adoption, and properly found the department's plan of adoption with the foster family, including his biological sister, with whom he had spent his entire life, served his best interests. Father accuses the department of failing to make reasonable efforts, but this argument is belied by the record. As an initial matter, to respond briefly, Justice Brennan, to your question, the department argues that this absolutely was waived. Under Rashida, clearly a motion could have been brought at any time during the case, and Father was represented by counsel at all times. And the reason for that is clear. If Father truly was not being provided the reasonable efforts to which he was entitled, there were opportunities to have that corrected by the department and by the court, and his failure to do so makes this claim untimely.
I don't see Rashida saying for the proposition that he had to raise this claim before trial. Your interpretation is he had to raise this claim before trial in order to preserve it?
Well, yes. So my interpretation is that he had to raise his claim before trial in order to preserve it. And for that, I don't point to Rashida so much as I would point to adoption of Gregory.
Gregory dealt with a specific case of a parent who had a disability. And it was the court found or concluded Gregory under that particular set of circumstances, my interpretation. I don't see it as broader that any reasonable efforts claim must be made before the trial begins. In fact, in West, the court, I think it was our colleague Justice Massing, determined a claim there, or reviewed, that court reviewed a claim that was made during trial and just decided that it wasn't sufficiently made. But then they said after trial is too late. So if I wasn't clear, essentially implicit in that decision is you can raise one during trial. They just found that that parent hadn't.
Well, I would point to Father's claim that he was deprived of the opportunity to bring this claim prior to trial, and I would say that that is not correct. He had every opportunity to do so. And the benefit of bringing it before trial is that it allows a judge to weigh in on the accuracy, because Father claims that the department made no efforts. The record reflects that the department it requested if it could make referrals. Father said no. The department attempted to meet with Father. Father said no. The department asked Father for his address. Father refused to provide it. So the record is replete with evidence that the department was making efforts. For Father to raise this at trial or thereafter and say they weren't made, it prevents a finder of fact from addressing this when it was before them and could be resolved.
They knew where he was when he was in jail.
The department did. I don't know exactly at what point the department knew where he was, but certainly, and the record shows that there was a conversation between Father and his social worker while he was in jail. So yes, they did.
And the judge didn't discredit his testimony that he asked for visitation while he was in jail, correct?
The judge indicated, I believe, an inability to know whether it was true. It didn't discredit it, but said Father claims that this was asked for. No evidence has been provided to support or deny.
But would a reasonable effort by DCF be encouraging visits between a child and a father who's incarcerated?
It would, yes. Statutorily, the department should be offering visits between a father and a father who is incarcerated and a child. And the record here fails to answer whether or not that happened. I would say that in the event it did not happen, in this case, it is not reversible error where the outcome would have been the same. I would point the panel to Carla and say that the outcome here was not impacted by any inability to visit. The court did not prejudice father for not visiting. It acknowledged that there may have been a custodial issue that impacted that late visitation, but father's termination was not predicated on any failure to visit during the time in which he was incarcerated. To the extent that the incarceration played a significant role in the court's findings, and it wasn't the only thing that the court relied on with regards to sufficiency, but to the extent that the court did rely on it, it relied on it as evidence of father's unfitness because he had a temperament, a desire to escalate that resulted in this constant incarceration. I believe before the child's birth, he had been incarcerated on 3 separate occasions for at least 9 months each time, and the court found that even if father were not held on those charges, he would likely run into further trouble. So I would point the panel here to adoption of Nicole as evidence that in and of itself, his incarceration was evidence of unfitness, was properly viewed by the court as evidence of unfitness.
Can you tell me where in the judge's findings she made a reasonable efforts determination?
Yes, so I would point the court to the panel, I apologize, to Record Appendix pages 4 through 12 contain reasonable efforts findings on the court's docket on November 20th, 2023, December 19th, 2023, and October 25th, 2023. So there were 3 findings prior to the initiation of trial. I apologize.
What I mean is
believe
at
October
the
25th.
termination.
What's that?
The judge's findings in terminating, what in her written findings, where did she make a reasonable efforts determination?
In her findings, she indicated that, I believe it was in her conclusion.
Well, I don't want to take your time. If you want to submit a letter, that's fine. If the panel agrees, we'll ask you to, but if you don't have it at your fingertips, you can move on.
Okay, I would just briefly point the panel to conclusion 21-2, where she indicates father was offered services but engaged in none. And I would also point to the frequent, and I can submit a letter, the frequent indications that father was offered services and was unwilling to engage in them. Conclusion 11, conclusion 15, conclusion 17, all indicate that the department did offer services which father refused to engage in. And again, as I believe I indicated, I mean, the record is clear that there were extensive efforts to engage father prior to his incarceration. And while it is true that he was incarcerated before he could start the 2 services which he testified that he started or tried to sign up for, he didn't try to sign up for those right when the child was removed. He waited. And I would point the panel to adoption of Dawn. It is clear in child welfare law that when parents wait, it is the children who suffer, and the trial judge was acting well within her discretion, and to quote adoption of Nancy, which you probably hear too much, to say, it's enough. I recognize that my sister indicated it was not a long period of time, but in fact, it was the child's entire life, and there had been almost no effort, and the court found almost no effort by father to make any effort to ameliorate his shortcomings. And she did credit that he had tried to sign up for 2 services, and she said it was unsustained and inconsistent. And she was correct in finding that because the record demonstrated he had not tried to do more. And so the fact that when the trial happened, he hadn't engaged in services, that wasn't because of the department's failure, it wasn't because of the court's failure, it was because of his inactions, which cannot now be laid at the department's door.
On the adoption issue, can you speak to why it took so long to get the birth certificate or the Social Security number card?
So the birth certificate, there's a process wherein it's requested, it's what procedurally is set forth by the department, and so it had done that, I understand, more than once. It was taking longer than normal. I can't speak to why. Well, I believe there was testimony that the department doesn't typically go outside of that policy. I would note, though, if father were submitting his sister as a plan, he could file a motion for an ICPC. He could go and get that birth certificate. So a parent has the ability to go to a juvenile court and propose an alternative plan. And had father engaged in the court process, perhaps that's something he would have done. With regards to the Social Security, I know I'm out of town, I just want to say, I don't believe that is a function of anything that can be done once the birth certificate is received, it's sent in. There's no real path around that. I apologize.
Thank you very much, Counsel.
Thank you very much, Your Honors.
Good morning, Your Honors. My name is Attorney Lena Wilson. I represent the child who will be 2 years old in November. And it is undisputable he's the only party that's entirely blameless in these circumstances. And I would remind the court that in these cases, the controlling standard is the child's best interest, which trumps outweighs the parental rights when the child's welfare is at risk. In this particular case, I would agree that the child was only 8 months old at the time of termination of parental rights. However, if you, I would like to point your attention to the fact that the father did not ask the court to place the child with his sister at the time of trial, which obviously means she couldn't do because of the lack of ICPC at the time. But he basically asked for more time. So he asked for delay in this child's permanency. And the judge refused to do that. She basically found that father was unfit, that there was clear and convincing evidence that he wasn't fit at the time of trial. It appears to me that father is not even arguing he was fit at the time. There was sufficient evidence that there was a pattern of violence and criminal conduct, which under adoption of Nicole is evidence which is clear and convincing of unfitness. There was failure to engage in services. I know father is saying, well, I couldn't engage because I was locked up. I mean, I am asking you to not hold his, he was locked up due to his own behavior. He was indeed held in 13 counts, which are pending. There was no trial yet, no trial date. And he couldn't point to how long he'll be unavailable to engage in those services. So the judge did make a finding that his unfitness was not temporary, as she pointed out to his conduct, which was consistent throughout his adulthood. I mean, he had been in trouble ever since he became an adult. He's been incarcerated 3 times for 9 months. The age of, he was only 28, 27 or 28, I believe, at the time of trial. He had not engaged in any kind of remedial behavior, which had landed him unfit or landed his child in care. He did not show up to court until he was caved in. And the judge basically found that he had abandoned the procedures. At one point, he didn't show up because, because there was an outstanding warrant, which would have led to his arrest. And the judge made a finding that he had prioritized his own liberty at that point versus engaging in the proceedings. As for adoption of Dora, the child does maintain that this case is clearly distinguishable because I specifically combed through the record to find where father proposed his sister as adoptive parent. He clearly said on the record at trial, I do not want my son to be adopted. Dora does require the judge to compare competing adoption plans, and the judge actually did say that in her findings that she's willing to adopt the child. I could not find evidence of that in the entire record, so that might have been an assumption on behalf of the judge. But that being said, I do believe that the right to propose or fight against that alternative plan, which might materialize in the future, did belong to the child because father did not propose that plan. And that's what the judge did. I mean, she basically stated that if the department decides to place the child with the sister, with the paternal aunt, the department should bring this matter to court so the child can object to it or request a hearing. And moreover, this case is distinguishable from Dora because the judge clearly made a finding that it is in the child's best interest to be adopted by this placement where his sister resided with him and where they're both being raised together. Therefore, there's no clear error, there's no error of law, And the child is asking that since the record supports the trial court's finding of father's unfitness and the determination that is in the child's best interest to be adopted by his current placement, I respectfully request on behalf of the child that the judgment is affirmed. Thank you.
I have a quick question. Most of the competing plan cases that I have found talk about competing adoption plans.
Correct.
Do you have a case that talks about an adoption plan proposed by DCF versus a custody plan proposed by the parent?
I do not. However, there is also competing adoption plans, which is the established law. And this is my argument that the judge was not required to compare adoption plan and other permanency plan. I mean, the sister said custody. Custody could mean guardianship. It could mean temporary custody. So that is my entire argument. That's not my entire argument, but with respect to Dora is that it is not controlling law in this case.
Okay. Thank you, counsel. It was very helpful. And our last case today is number 2024 P1025, Jordan ARBIT, doing business as ARBIT Chiropractic versus Premier Insurance Company of Massachusetts and another. Mr. Powers, when you're ready, you may proceed.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the Court. Kevin Powers for ARBIT Chiropractic. In Surrey, Your Honors, the SJC embraced what this Court in Mendonca called the non-literal approach to motor vehicle insurance interpretation, both at the statutory and the policy level. Choosing the purpose of the law, the spirit of the law, over a hyper-literal letter of the law. Here, the car sped at this, I believe, 69-year-old woman who scared, fell, and trying to retreat, fell and crawled on her feet as described at Record Appendix Volume 1, page 58, and Volume 2, page 58. Happens to be page 58 in both volumes. Your Honors, the legislature never intended for there to be a gap in PIP coverage under these circumstances. PIP coverage is supposed to simplify the process for that tiny initial $2,000 to $8,000 of immediate medical expenses so that nobody needs to worry about can an individual injured in a situation involving an automobile get that initial treatment without having to resort to the fault-based tort system and the prolonged march through litigation that it so often entails. What happens after that $2,000 to $8,000 threshold? Then we get into the fault-based system. But at the initial PIP stage, we're not taking out a scanning electron microscope and scrutinizing every little detail. It's supposed to be broad. It's supposed to be prompt. And in doing that, the original purpose of the legislature was to reduce the cost of insurance by making this very, very easy to process and very, very broad-based. So broad, in fact, that pedestrian not only encompasses those walking on foot, but also encompasses equestrians on horseback, bicyclists.
So I get what you're saying, but if we're trying to reduce the cost of insurance and simplify, might not broadening the interpretation have actually the opposite effect? So, for example, what does it take if I'm walking down the street on the sidewalk and a car seems to come close and I jump because I'm frightened and then I twist my ankle? Is the driver liable?
And I think, Your Honor, that the lesson that we take from the Cherwin case in Florida is that the analysis that we apply there is causation, proximate causation, but for causation. And that's where we can have a cutoff in terms of was the automobile a cause in fact? Was it a proximate cause? Was it a but-for cause?
Why shouldn't we conclude that what the legislature concluded in enacting 34A is that causation is presumed when the pedestrian is struck with physical contact by the motor vehicle?
Because, number one, Your Honor, that would thwart the broad purpose of PIP. But number two, Your Honor, looking at the history of the legislation and the original 1969 and January of 1970 draft, we see, and that's included in our addendum. We see that the phrase "struck by" was originally intended to be synonymous with the phrase "injured by," and the only reason why "injured by" did not survive to the final version of the statute was not because the legislature deliberately intended to remove the phrase. No such thing. Instead...
But what do we do with all the cases that say if the plain language of the statute is clear, you don't need to get to legislative history?
Because, Your Honor, as Florida, West Virginia, Mississippi, American jurisprudence, and the American law reports all instruct, the phrase "struck by" in this context is ambiguous. It is ambiguous. I realize that my brother very enthusiastically argues that it is unambiguous. But our position, Your Honors, and certainly the clear position of Florida, West Virginia, Mississippi, the trial judge in the Massachusetts appellate division of the district court in Baum from about 15 years ago.
So in 34O, when the legislature talks about cases in which the insured motor vehicle is struck in the rear by another vehicle owned by another person traveling in the same direction.
Yes, Your Honor.
Are you saying that that struck doesn't necessarily require a touching of one car on the other if a car's tailgating and the front driver panics and drives off the road?
Your Honor,
is injured? Then there'd be PIP coverage?
Your Honor, I would offer up the hypothetical that we discuss in our reply brief on that precise point. Suppose that a driver is driving along and happens to notice in the rear view mirror a car behind him or her approaching at a high rate of speed. So our driver in the front accelerates. In the course of accelerating, our driver in the front hits a telephone pole, hits a wall, hits the side barrier on a highway. I'm forgetting the technical term, but I think we all know the barrier at the side of an interstate. And I would submit to Your Honor that the same ambiguity exists there under that circumstance in terms of struck by. And I would also note, Your Honor, in both that situation and the situation in this case of the pedestrian ultimately making physical contact with the ground. And this is a point that the Mass Academy of Trial Attorneys makes in their amicus letter. Ultimately, there was physical contact with an object. The object just happened to be the ground. And in our hypothetical about the rear end collision, the physical contact would happen to be the telephone pole, would happen to be the barrier, would happen to be the wall. So
slightly different example. What happens currently in PIP context if a car cuts off another car and the second car swerves suddenly, so the first one's at fault, swerves, and there's no contact made between the cars, and you just say hits a telephone pole and people inside are injured. PIP covered?
Yes, and there wouldn't be a problem there because PIP being by its very nature no
Yes,
fault,
'cause you're in the car, yeah.
it doesn't require another vehicle to be at fault.
Right.
And so the PIP coverage of the vehicle that swerves out of the way and then collides with a wall or telephone pole, whatever it happens to be, that car's PIP coverage would apply.
Okay. Oh, fair enough. Okay. Yep, makes sense. Sorry.
So I would just emphasize that it's PIP fundamentally is this small amount of money. It's to be broad, it's to be prompt, it's to shift the risk of loss to the insurance carrier, which is subrogated and has the right to pursue any at-fault party if there is an at-fault party in the tort system. And it's mandatory in every mass auto policy. But, Your Honors, here, if this court accepted my brother's rule, there would be a gap in what is otherwise intended to be all-encompassing. And when I say all-encompassing, I mean in any situation in which an automobile is involved, whether the opposite party is also in an automobile, whether the opposite party is on foot, on horseback, in a bicycle, in a horse-drawn carriage, in any situation where there's at least one automobile involved, PIP says there will be that $2,000 to $8,000 of initial coverage to ensure that someone who is injured is able to get initial treatment without having to deal with, oh no, I have a very, very high deductible health insurance policy. Can I really afford to go and get treated?
Aren't you asking us to read the statute to do an end run around any causation requirement in situations where there's no contact?
No, Your Honor, because if for example, suppose that, and I'm coming up with a hypothetical at the top of my head, but I'll try to improvise as best I can. Suppose someone is walking along in a field at a state park, and there's a road quite a ways away, and off in the distance the person sees a car. And that car is driving all over the road, nowhere near this individual, and is not coming anywhere near the park, but because there doesn't happen to be enough tree cover, this person can see all the way across the field to this car swerving all over the road. This person, for whatever reason, is a bit of a busybody and is annoyed at the fact that there's this terrible driver out there, and that person has some reaction totally beyond the pale and somehow attributes that in retrospect to having witnessed that driver maneuvering completely erratically. We would say under those circumstances, I think, and I think any trier of fact would say under those circumstances, that there is no causation there. There is no but-for causation. There is no proximate causation. Perhaps I could come up with a better hypothetical, but if Your Honors will forgive me, I am improvising on the spot.
Where does a causation determination take place in the PIP framework, though?
Well, hopefully, the carrier will undertake a reasonable analysis that will later hold up if the question has to be litigated. But the carrier takes a risk in denying a PIP claim that a court will later find that indeed PIP is due an owing. And under those circumstances, not only is PIP due, but also fee shifting is due. And that's the risk that a carrier takes. And it's reasonable to place that, that risk on the...
Okay, so I'm sorry. So as I understand it, what you're saying is that in between your hypothetical with the person way in the distance and a hypothetical where the car drives by the person on the and seems to be really tight to the person on the sidewalk and then maybe even swerves slightly and the person jumps out of the way and hits that off a street sign, that the insurance carrier has to make a determination. It's either covered or not covered, but if they make the latter determination, they run the risk of, as you say, if there's a claim in court, then they got to pay legal fees.
Yes, Your Honor, and
that's up to them to reduce. Okay.
Yes, Your Honor, and this makes sense, Your Honor, to have that risk fall on the PIP carrier precisely because the amount of money is so small. We're not talking here about a $25,000, used to be $20,000, was recently updated $25,000 bodily injury coverage, or uninsured motorist coverage, or even if we have a responsible policyholder as much higher coverage limits, we could be talking about much larger numbers. PIP is very tiny. It's frequently no more than $2,000. In all circumstances, it's never more than $8,000. And as a result, yes, the pressure of the statute and the pressure of the PIP system is exerted on the carrier to say, you know what, when in doubt, allow the PIP claim, because PIP is not the type of coverage in which we get into scrutinizing the nitty-gritty details. There are those coverages, bodily injury coverage, uninsured motorist coverage, but not PIP because it's such a small amount of money. And so I see that my time is up. I'm glad to answer any other questions, but...
I don't see any other questions, so thank you, counsel. Very helpful.
Thank you, Your Honor, and on the basis of those arguments and the arguments articulated in our briefs, we respectfully request that this court reverse the grant of summary judgment in favor of travelers and grant summary judgment in favor of ARBIT. Thank you, Your Honors.
May it please the Court. Wyston Ackerman for Standard Fire Insurance Company. The issue presented here is straightforward and simple, and the applicable principles of insurance law are straightforward. Both the policy and the statute provide that there's coverage only if a pedestrian is struck by your auto. It doesn't say frightened by, it doesn't say getting close to, it says struck by your auto. The SJC has instructed in cases such as Chenard and Gomez that we apply the ordinary and usual meaning as commonly understood by a reasonably intelligent person. The ordinary and reasonable meaning of struck by your auto is physical contact. You don't need to go to a dictionary even to know that. If you ask the average person on the street this question, they would look at you very strangely if you suggested that being frightened by an auto is being struck by an auto.
Well,
That's
they may
not,
do the same with hit and run, though, no?
I'm sorry, Your Honor.
Would there not be, this person on the street, would they not have a similar reaction to hit and run? To hit means hit, struck means struck?
In the Surrey case, the SJC was interpreting hit and run as a phrase, as the three words together. They looked at that in a dictionary and they realized that actually that dictionaries as well as statutes, and they looked at a criminal statute, they looked at a statute of limitations, all of those sort of pointed to leaving the scene of an accident as opposed to necessarily being hit. So that is hit and run is a term of art that had a special meaning that was applied.
Right, but leaving the scene of an accident inherently, it seems to me, involves a hit. That's the hit part of the run, and then the run is the leave part. No?
I mean, that was an argument made in that case. They rejected it based on statutory definitions of what that means and based on a dictionary definitions. But here, we don't have dictionary definitions that tell you that struck means getting close to and scaring someone. Even the dictionary definition that My brother cites is sort of attack someone or something forcefully or violently. That's a British dictionary. Again, that points to physical contact. The dictionary that the appellate division cited was come into contact or collision. That's physical contact. There are numerous cases that apply plain meaning here. And another point that I think is important and goes to one of Justice Brennan's questions is the plaintiff really offers no workable alternative interpretation of the policy that makes sense and could reasonably be applied to other scenarios. The standard that they seek would be, and after listening to the argument, I'm really not sure what it is, but it'd be some sort of rewriting of the policy, taking those words out of the policy and substituting some causation standard. And there were questions about, well, is causation part of the analysis? And if you go to the PIP coverage, this is Record Appendix Volume 2 at page 26, there's 3 different ways of getting coverage. One is if you're injured while occupying your auto, so that doesn't really point to causation. You just have to be occupying your auto. If you're injured while occupying an auto that doesn't have insurance, so again, it's not really speaking to causation. It's a question of, is the injured person occupying the auto? And then the third one is the one we're here today for, which is if the pedestrian is struck by your auto. So those are all easy to apply. You can easily determine whether someone is in an automobile or whether they're struck as a pedestrian by an automobile. It doesn't really speak to a causation standard, and creating a causation standard would be rewriting, I think, both the statute and the policy. There's been discussion about the statute, uninsured motorist, and also the uninsured motorist policy. One point I wanted to make there is the statute is different, and it was enacted a couple years before the PIP statute. The statute was enacted in 1968, and it provides for coverage for persons, quote, who are legally entitled to recover damages from owners or operators of uninsured motor vehicles, and it goes on. So that statute was broader, and the intent was clearly on its face to provide coverage essentially to the full extent of tort law if you're legally entitled to recover damages. The general court could have written the PIP statute like that. They could have written it legally entitled to recover damages. I believe some of the states from other jurisdictions might do it that way, but they didn't do that way. They did it very differently. They said struck by your auto, and they've had many opportunities to amend it since 1970. The language at issue goes back to 1970. This issue that we're here about today could have been raised at any time in the last 55 years. They've amended the statute 6 times since 1970, and they've never changed it. So I think that's important. There was also...
Do you have anything to say about the Baum appellate division case?
Yeah, I mean, the Baum case, all it does is it has a footnote that quotes from a trial court, district court case that suggests that if someone was actually thinking about the availability of insurance coverage when someone is coming at them, then they would make a choice between getting out of the way or getting hit so they can collect...
Standing their ground.
So standing their ground so they can collect $8,000. I don't think anybody in their right mind would stand their ground to collect $8,000. It doesn't make any sense. The other thing that doesn't make sense is you can sue under tort law. So the plaintiff here, or as Mr. Powers pointed out, the plaintiff here could sue the standard fire insured under tort law and say, you caused this accident.
As Baum did.
As Baum did, I believe. And so you can recover that way. There's no necessity of PIP coverage, and actually you have more coverage under the policy here. You'd have $50,000 of coverage for just general bodily injury coverage, but you have to prove negligence, you have to prove causation and harm, you have to litigate it that way. So I think anyone, it's a strange way to interpret insurance policies, and I don't think the proper way would not be proper to interpret a policy based on what someone might do in the scenario if they're thinking about coverage. That's not how policies are interpreted. They're interpreted based on the plain language and the case law. But if anyone was doing that, the practical way to approach it would be to get out of the way and then pursue it under tort law. There's a lot of cases from other jurisdictions that are cited. The Given case by the SJC makes clear that the cases in other jurisdictions in this scenario are of limited utility in construing the Massachusetts policy because it's construed, it has to be construed based on its own specific language, which is approved by the Commissioner of Insurance. And it is a standard policy here that's approved by the Commissioner and also the governing statutes. So they generally, Massachusetts courts generally have not looked to other jurisdictions in construing the standard policy. Here there are 5 states we've cited that construe struck by your auto or very similar language to that, the way that we're advocating for. That's Georgia, New Jersey, Kansas, Idaho, and Virginia. And in New Jersey in particular, there was a legislative amendment that inserted the word struck by to narrow the statute and make it more clear. And so that's what was done here from the beginning in Massachusetts in using that particular language. There was some discussion about the legislative history. I'll touch on that briefly. As I mentioned, I think the UM statute compared to the PIP statute demonstrates an intent to be narrower in the PIP statute and consistent with our position. The original bill that my brother cites, original bill from 1970 said that pedestrians struck by the insured motor vehicle was going to be the scope of coverage. That stayed in the enactment. What he focuses on is language that PIP benefits would be excess over collateral benefits for pedestrians injured by the insured motor vehicle. I think that demonstrates that if the legislature wanted the broader language in the grant of coverage, the part that's actually saying what's covered under the policy, they would have put the pedestrians injured by the insured motor vehicle in the grant of coverage. And that's somewhat similar to what was done in the uninsured motorist context. But that's not their choice here. So I think the legislative history, to the extent you even need to go there, and I don't know that you do, further supports our position. There are cases from other jurisdictions. He cited some that essentially found that the policy either was contrary to a statute. That's not the case here. It's identical language. Or the court, just as a matter of public policy, decided to do something different, creating its own rule with a corroboration requirement. That's what West Virginia did. Mississippi sort of did something similar, just making a policy judgment. That's not what Massachusetts courts do. That's not how policies are construed here. That's the Hahn case from this court that we cited, the Westerland case from the SJC as well. Plaintiff cites no Massachusetts case that departs from an insurance policy in this kind of manner and construes it inconsistent with the plain language of both the policy and the statute, where both have identical language. So, and I think really the only reason we're here, as Mr. Powers pointed out, is the fee shifting. I mean, this is a $3,700 case. We wouldn't be here except for the fact that the statute provides for the potential for attorney's fees and the plain language and of both the policy and the statute control. Unless the court has further questions, we ask that the court affirm the decision of the appellate division.
Just a general question, and it's a little bit maybe repetitive what you argue, but when you're looking at the PIP benefits provided, and again, there are 3 different categories. In following the categories, the language references injured person. Or let me just ask afresh. It seems like the intent, an argument could be made that the intent of the statute is to provide for injured people. And this goes back in part to your brother's argument that the legislature used injured and struck before. But isn't it consistent with moving things along quickly, avoiding litigation, that the statute is really designed to provide treatment for injured people as opposed to struck people?
I mean, I think the statute is designed to provide treatment for certain injuries that have something to do with an automobile, but it's more specific than that. I mean, it's the policy says injured while occupying your auto, injured while occupying an uninsured auto, or struck by your auto as a pedestrian. So it's really, it has to be tied to an auto, obviously. And in this context, we don't have anyone occupying an auto. So, I mean, in the example that was given about just one car sideswipes another, the coverage would not be found under the car that's moving in a negligent manner because the person that's injured is not occupying that auto. The only coverage would be under, and there's no fault coverage, so the coverage would be under the auto of the driver that may have done everything appropriate. They're just, that's the way this works. There's no fault coverage because the injured person was occupying that auto. That driver may have been not negligent at all. They were sideswiped by somebody else that's at fault, but the coverage is not under the policy of the person that's at fault. The coverage under this policy and the way the statute is designed is under the, either you have to be occupying an auto or you are struck by an auto when you're a pedestrian, bicyclist, the pedestrian as defined by the statute and the policy.
So if this driver had taken off, and this other facts were exactly the same, and there was no contact, the woman fell because she was nervous and the driver took off, would there be coverage under the uninsured auto part of this, or, sorry, hit and run, I guess we call it, provision?
Well, there would be no PIP coverage because she was not occupying the auto. As to whether there would be uninsured motorist coverage under the Surrey case, she could potentially pursue uninsured motorist coverage.
Thank you. If there's no other questions, that concludes our sitting today. Thank you all. And thank you to our court officers and our recorder.